On 3rd of July 2026, a film called Satluj went live on a Z5.
1995 पंजाब, जहाँ एक तरफ पुलिस फोर्स मिलिटेंसी हटाने में लगी हुई थी, पुलिस के नाम वापस ले ले, वरना यहीं गाड़ दूंगा जिंदा।
48 hours later, it was gone from Indian screens. Not banned by the Central Board of Film Certification, India's official censor for theatres, but pulled under a completely different law most of the viewers have never heard of, buried inside the Information Technology Act. Now that gap between the law everyone assumes governs what we watch and the law that actually got used here is the real story. And it tells you almost everything about how content control in India actually works in the year 2026. Now, Satluj is a biographical movie directed by Haneet Rehan, starring Diljit Dosanjh, Arjun Rampal and Subinder Vicky, based on the life of Jaswant Singh Khalra ji. A bank employee in Amritsar who in early 1990s began investigating unclaimed bodies quietly cremated by Punjab police during the insurgency years. Now, Khalra's inquiry alleged that thousands of people who had disappeared were being cremated without any record and without informing their families. Now, he was abducted in 1995 and killed. Several police officers were later convicted in connection with his murder. Now, the film had a punishing road to release. Under its earlier titles, Kallukara and then Punjab 95, the CBFC reportedly demanded around 127 cuts before it would certify the film for cinemas. Now, Rehan and Diljit, of course, refused and the theatrical release never happened. So the makers did something that's become increasingly common in India. They skipped cinemas altogether and released straight to a streaming platform where, on paper, the certification hurdle doesn't exist. Z5 marketed it as the uncut version, and 2 days later, it vanished from Indian accounts. Now, with Z5 issuing a brief statement that the film would not be available in light of the current developments, when it explored every appropriate avenue through due process. Now, here's the part that actually matters for understanding modern India, not just this one film. India does not have one system for regulating what we watch. It has two. They don't talk to each other. Our film headed for cinema halls fall under the Cinematograph Act of 1952, which set up the CBFC, Central Board for Film Certification, as a pre-publication gatekeeper. Nothing gets shown in a theatre without a certificate first. Section 5B of that act lets the board refuse a certification or demand cuts on grounds that mirror Article 19, Section 2 of Indian Constitution, which includes threats to sovereignty and integrity, state security, public order, decency, defamation, contempt of court. Now, the 2023 amendment to the Act added age-graded subcategories and made certificates valid for life instead of expiring after 10 years, but the core model stayed the same. Now, it means approval before you can show the film to anyone. Now, streaming never went through that door. In 2019, Karnataka High Court ruled in Padmanabh Shankar versus Union of India that content transmitted over the internet does not mean the legal definition of cinematograph at all. So the 1952 Act simply doesn't reach it. And then a year later, the Delhi High Court made a similar point in the Justice for Rights Foundation versus Union of India case. Now, for a while, that left OTT platforms operating on nothing but their own community guidelines. No statutory certificate required at all. But then the government closed that gap on February 2021 with Part 3 of IT rules, which created a code of ethics for digital publishers and a 3-tier grievance system. The platform handles complaints first, that's the first tier, then an industry self-regulatory body, that is second tier, and only at the top does the Information and Broadcasting Ministry, INB Ministry, steps in, that is the third tier. Now, crucially, this is a post-publication framework. Nobody pre-approves a web series in our country. On streaming platforms, you publish first, and the machinery only engages if someone complains. Now, that difference is exactly why Satluj went to Z5 in the first place. Under the Cinematograph Act, the makers had already lost 127 7 demanded cuts were there, no certificate was given, no cinema release. Under the IT rules, there's no equivalent gate to walk through before release. It looked briefly like a legitimate way to get an uncut film in front of Indian audiences without asking the CBFC's permission at all. Except the government didn't need the Cinematograph Act to stop it. It reached for Section 69A of the Information Technology Act instead, a provision that has nothing to do with film certification and everything to do with blocking access to information already published. Reporting around the takedown indicates an interdepartmental committee under the IT rules was activated to examine the film, and then the removal was tied to security-related concerns rather than the content classification grounds a censor board would normally invoke. And this is the mechanism used to block websites, apps, and now apparently a streaming title, all without the film ever being submitted to or rejected by the CBFC. Now this matters because it exposes something people rarely think through. The light touch reputation of OTT regulation only covers pre-publication certification. It says nothing about the government's post-publication power to make content disappear anyway. There is Section 69A. It was tested at the Supreme Court back in 2015 in the Shreya Singhal versus Union of India case, the same judgment that famously struck down Section 66A for chilling online speech. Now, the court actually upheld 69A, but on the conditional basis, it called the provision narrowly drawn, specifically because it came bundled with procedural safeguards under the 2009 blocking rules, a written, reasoned order, a hearing for the originator of the content under Rule 8, scrutiny by the review committee under Rule 14, and the theoretical ability to challenge the order in any court under Article 226. In other words, the court didn't say blocking power is automatically fine if those safeguards are real and not paper ones. That's where things get genuinely contested. See, the Rule 16 of the same 2009 blocking rules imposes strict confidentiality on blocking requests and orders. The government has interpreted this to mean it doesn't have to disclose blocking orders even to the person who made the content. Journalist and satirist Tanul Thakur discovered this the hard way in 2018 when his website was blocked under Section 69A and he wasn't shown the order or given a hearing until years of litigation forced a partial disclosure. Now, legal researchers writing this year have gone further, arguing that newer amendments to the IT rules released in March 2026, while older constitutional challenges to a 2021 framework were still pending before the Bombay and Madras High Court, don't define this architecture so much as widen it in ways that sit awkwardly with what the Supreme Court actually approved in 2015. Now, PIL was filed in the Punjab and Haryana High Court in July 9th of 2026, specifically challenging the Satluj takedown on these grounds, arguing that removing the film without disclosing any statutory order or judicial direction violated both due process and the public's right to receive information under Article 19, Section 1. Now, let us try to understand what the numbers actually show about the CBFC. It's worth pausing on how rare an outright CBFC refusal actually is, because it reframes what happened here. Government data placed before the Rajya Sabha shows that the CBFC certified around 71,963 films 2020-21 and 2024-2025. Out of that entire five-year pool, only 3 films were refused certification outright. 1 in 2022-23, 2 in 24-25. Now, cuts and modifications are a different story. Those climbed steadily from around 1,475 in 2020 to around 3,000 in 24-25, meaning the board's real leverage isn't blanket bans, it's negotiated edits. See, a film demanded to make 127 cuts, as Satluj earlier version reportedly was, sits at the extreme end of that spectrum. Most filmmakers who hit resistance end up trimming a handful of scenes and moving on, not absconding theatrical release entirely. Historically, outright bans have happened in clusters. An RTI response covering 2000 to 2016 found around 793 films refused certification over 16 years, peaking at 153 in a single year in 2015-2016. But the recent trend towards near zero refusals suggests the board increasingly prefers editing content into acceptability over blocking it outright. Now, Satluj makers chose not to play that negotiation, and that refusal to compromise on cuts is precisely what pushed the film out of the CBFC jurisdiction and into the IT rules, where, as it turned out, a different arm of government could still reach it, just later and through a different door. Now, there were some unplanned consequences as well. And what happened after the takedown is its own case study in how blocking works or it doesn't in a country of over 1 billion internet users. See, pirated copies are spread within hours across WhatsApp, Telegram, and YouTube. Several Sikh organizations and local residents began organizing community screenings in gurdwaras and village halls across several states, using those same circulating copies, turning temple compounds into makeshift cinemas. Now, Forbes contributor described the backlash as a textbook street sand effect, an attempt to restrict access, generating far more attention and reach than the film would likely have gotten on a subscription platform alone. Now, this is the structural weakness of a post-publication blocking that pre-publication certification doesn't share. Once a film has already streamed, even briefly, removing it from one legal platform doesn't remove it from circulation. It just moves the audience to unregulated, unmonetized, and copyright-infringing channels, which is a worse outcome by almost every metric the government claims to care about. From piracy control to content oversight, it is the worst option for the government. Now let us try to discuss on where the architecture currently existing is actually headed to. Let's zoom out, and the Satluj case sits inside a very larger, unresolved argument about whether India should even keep two separate systems. So the 2023 Broadcasting Services Regulation Bill tried to fold OTT platforms into a unified broadcasting framework alongside television and film, but it was withdrawn after industry pushback. Now separately, the 2023 amendment to the Cinematograph Act already allows a single theatrical certificate to cover a film's OTT and television release too. A small but telling signal that the government sees convergence and not separation as the direction of travel. Meaning, the tribunal that used to hear appeals against CBFC decisions, the Film Certification Appellate Tribunal, was abolished in 2021, with its function shifted to the High Courts, which legal commentators note has made appeals slower and pricier and removed a body with specialized expertise in film adjudication. None of this resolves the deeper question that Satluj case has forced into the open. If content can be pulled from a streaming platform without ever going through a certification process, using a statute that was written for internet infrastructure rather than film content, then the real distinction in Indian content regulation isn't theaters versus streaming anymore. It's a regulation you can see coming versus regulation you can't. And which side of that line a film lands up on may end up mattering more than which platform it was ever meant to release on. Now, the certification controversy with this particular film raises a much larger question over censorship and over content modulation and regulation in our country. Now, these kind of films should be restricted, should be moderated in our country or not, and should it be done by an authority which is regulated by the government? Should it be given that much power? And there is, on one side, there is content regulation, and on another side, there is Article 19, freedom of speech and expression. And what is more important for the country, and what is against the sovereignty, integrity, and security of the country? Who is to decide this is the real question as of now. Do let me know what is your opinion regarding this. That should censorship be given more importance or Article 19? The answer is up to you. Let me know in the comment section. All the very best. Have a beautiful day. Thank you.